Greetings, dear colleagues, candidates, and the public. Today, on January 15th, 2025, the advisory group of experts met in the full force to conduct an interview with the candidate for the position of Judge of the Constitutional Court of Ukraine, Vladyslav Ivanovich Ivashchenko. In particular, all 6 members of the DG are present. Secretary of the AG, Maureen O'Connor, member of the DG, Hanna Sukhotska, members of the AG, Yaroslav Romaniuk, Vasil Shakun, Aleš Zeller, as well as myself, the head of the AG, Oksana Vasilchenko. During the interview were 5 deputy members of the AG, Thomas Griffith, Richard Barrett, Marek Zubik. I note that we work in a shelter, so in the event of an air raid, interviews will continue without interruption. I would also like to remind you that the interview is being recorded and broadcast live on the resources of the State Enterprise and the website of the Constitutional Court of Ukraine. I draw the attention of the members of the AG and the candidate to the restriction of the use of sensitive data and information with limited access on the air. If it is necessary to discuss such issues, the AG will limit the broadcast at this time. We are ready to begin, so I give the floor to AG Secretary Maureen O'Connor for a brief introduction of the candidate and a reminder of the interview schedule. Maureen, please.
Thank you, Madam Chair. Good morning, ladies and gentlemen. Greetings, dear colleagues, and everyone who is watching this morning. As Ms. Ivashchenko has already said, the advisory group of experts will now conduct an interview with the candidate, Vladyslav Ivashchenko. Let me remind you that the interview is a mandatory stage of evaluating candidates as part of assessing their compliance with the criterion of high moral qualities. One interview is given approximately up to 1 hour, and the time limit for answering questions is up to 3 minutes. Traditionally, we ask candidates to be concise, to answer clearly, unambiguously, and the essence of the question that has been asked. At the end of the interview, the candidate may make a short final statement up to 5 minutes. I would also like to note that during the processing of materials about the candidate, Ivashchenko, the state educational institution sent him questions to provide written explanations so the candidate had the opportunity to prepare and to provide answers. So now we have with us a candidate for the position of Judge of the Constitutional Court of Ukraine, Vladyslav Ivashchenko, who is simultaneously admitted to the competitive selection by the Committee of the Rada of Ukraine and the Competition Commission under the President of Ukraine. Mr. Ivashchenko has been a lawyer since 2017. He was Deputy General Director of Euro Construction LLC from 2014 to 2017, Deputy Chairman of the Board for Legal Affairs PJSC Eco Standard from 2011 to 2012. He was also a state expert and deputy head of the Financial Security Department, the National Security and Defense Council of Ukraine from 2005 to 2011, prosecutor of the Kyiv region and the Chernobyl Environmental Prosecutor's Office 2002 to 2005, investigator of the Prosecutor's Office of Cherkasy region and Cherkasy district 2000 to 2002, and a police investigator from 1999 to 2000. Mr. Ivashchenko, if you want to add something to your presentation, you can do that now within 2 to 3 minutes. We will begin.
No, thank you.
Добре, тоді ми перейдемо безпосередньо.
Great, so let's proceed with the interview and with the questions from AG. Namely, during written communication with AG, you had different explanations regarding your participation in the competition for the position of a member of the High Council of Justice in the Declaration of Integrity. In particular, In 2021, you were found guilty of committing an administrative offense. However, it was not included in your declaration. Since the explanation that you provided during written communication are contradictory, could you please explain us? Did you or did you not violate the rules for filling out the declaration of integrity? Or do you believe that these rules are of poor quality or unfair? As of now, what is your conclusion? Why did you not have an obligation to indicate in the Declaration of Integrity cases of prosecution? Thank you for your question. In my previous explanations, I did not want to be categorical to the questions of the AG, but I believe that the conclusion regarding incorrect or violation of filling out of the declaration is not meeting the requirement of current legislation. And I believe that the Council made a mistake. Initially, the Declaration of Integrity was one step, and the conclusion was that I made a mistake in the declaration for the candidate of the judge. Also, I filled in this declaration in October 2023, and in November 2023, so a month later, these rules were changed, and the Ethical Council, in their conclusions, applied the rules that came into power after I filled in the declaration. And also, they applied the rules of a different type of the declaration. A declaration not for the candidate, but for the judge. So I believe that in this case, this conclusion does not meet the requirements of current legislation, and I believe that I did not violate the rules for filling out the Declaration of Integrity. I believe that I filled it in according to the rules that were in power as of October 2023. At the same time, I also explained that the competition for the position of the council was supposed to be clear, and as far as I know, one of the candidates filled out the declaration a year before, and I myself, when it comes to the administration violation, I was supposed to fill in the information for all 32 years, and I only had 10 days to fill out this documentation. So even the approach of the competition was not competition-like. Not to say that I believe that Ethics Council made an incorrect conclusion. So in my first response to your written requests, I tried to stay polite. However, since this is the third time when I hear this question, I explain it the way it is. I believe that in this case, the Ethics Council applied these rules incorrectly. Today, we obviously discuss the decision of the Ethics Council, and one of the points of integrity, one of the pillars of integrity is diligence. And if you believe that the rules are incorrect, or this is your own interpretation of the rules for filling out the declaration, or if you do not agree with this approach to fill out the declaration in this way, this is what we want to understand. We do not discuss the decision of the Ethics Council. I understand the question. I believe that I was quite diligent in filling out the declaration. Obviously, I made a violation, and I believe that this violation doesn't have any signs of integrity. This was a typical insurance case for a minor car accident, and together with another driver agreed to fill out the case to insurance. I didn't have any problems here. I didn't have any motive to cover up for this insurance case, for the necessity to repaint someone else's car, and I did not leave the site of the car accident. I myself called the police in this case, and this was a standard procedure. I do not see any reason for me to cover up for this fact. And I believe that I was supposed to fill in the declaration for 2022, and I did not have any violations in 2022. So this is how I understood these rules. And from my understanding, I was diligent and I stuck to integrity when filling out the declaration. Thank you. Madam Hanna, please.
Now I have a question concerning the car Toyota, because on November 2022, under the sale and purchase agreement, you acquired ownership of a Toyota Land Cruiser Prado 150 2022 car. On April, you gave your wife Arbatova this car belonging to you free of charge. The cost of the specified gift by the parties is determined in the amount of Ukrainian hryvnia, about 1,500,000. In the response to the advisory group's question, you said that this vehicle had been planned from the very beginning as a gift to your wife and to help raise the children. However, during the interviews to the position of a member to the High Council of Justice, you explained that the council that after purchasing this vehicle in your name, you decided to renew your wife's driving skills, and then you decided to give her this car. In the advisory group, you gave another explanation because you said that there was no reason to rush to register. You also indicated literally, why do I personally need two cars? I am not Bashar al-Assad. So there's two questions, yes? Why your explanation to the Ethics Council and the advisory groups about the motives for donating this car were different? And then, I have some questions concerning why you use this language in front of the advisory groups that I am not Bashar al-Assad. Do you think that it is just a good, behavior as a candidate for a judge to the Constitutional Court? So those are my questions to you.
Thank you for your question. I would like to point out that I presented the information regarding both my cars, and both the car that is registered for my name and for my wife's name have a very basic complex of features. So it is a very basic functional feature, and this is the way I treat any car. For me, this is not a luxury. In my family, there is me and my wife. That is why we have two cars. I had my own car. My children grew up and my wife needed a car. Therefore, I purchased the vehicle in November 2022. I purchased the vehicle and registered it in my name since I made the purchase in Kyiv and I need to move it from Kyiv to Khmelnytsky. So initially, I bought the car in my name. It was winter. In winter, my wife understood that she doesn't have the skills to drive this car, so no one used this car throughout the winter. And then in spring, once she was able to update her driving skills, I gave this car to her free of charge. Why did I use this specific mechanism? It is because it's not possible to register the property for two people. I do not see any discrepancies in this. There are two of us, so the second car was needed and was purchased for my car. Why did I compare myself to Bashar al-Assad? I just wanted to show that any car is not a luxury for me. For me, this is not an item of collection. It is just a functional thing. That is why I used this comparison. Because for me, this is a clear situation. There are two of us, so we need two cars of very basic features for me and for my wife. I do not see any unusual activities here. Thank you.
Yes, thank you. And now I have another question concerning errors in the declarations. In section 11, income including gifts of the corrected declaration of a candidate for the position of a person authorized to perform the functions of the state or local self-government, you indicated information about your wife's receipt of income in the form of wage and insurance payments. However, in the column source of income, you indicated the data of the wife and not information about the individual of legal entity that actually accrued such income to your wife. In response to the question of the advisory group of experts, you explained that your wife could not find out and provide you with the exact EDRPOU code and the correct name of the budget fund manager who transferred this fund. Later, you explained that in such a situation, you had the right to put a mark in the declaration a family member did not provide information. And therefore, in this case, your actions were correct. What is your answer to this whole problem? Do you admit that this method of displaying your wife's sources of income is erroneous precisely from the point of view of the rules for filling out the declaration, and not your understanding of the purpose of submitting such a declaration? And you, as a professional lawyer, took measures to find out the exact EDRPU code and the correct name of the budget funds manager who transferred these funds to your wife. So there is such an incongruence in the fulfilling the declaration. How you can explain it?
Thank you for your question. I would like to point out that these declarations I filled in as a candidate. So, as an attorney, I do not have a professional obligation to fill in these declarations. That is why the responsibility for any mistakes in the declaration, according to the legislation of Ukraine, is held by the registered candidates to the position of the President of Ukraine as well as Deputy of Verkhovna Rada. That is why, for any minor mistakes, the candidate that is an attorney, so a civil entity, is not responsible. Yes, I did not have sufficient time. I typically take a week or 10 days to fill in all documentation, and according to the rules, I was supposed to write that my wife did not provide this information. The sum is 860 hryvnias per month, which is not a significant sum of money, but me not stating the source of income for my wife and mentioning her as the source of income, what from the point of view of formality, this was not the way to do this. I should have written down that my wife did not explain the source of income. But since the filling out of declaration as a candidate is just for the commission to assess me as a candidate, and I do not think that it would be correct if I just mentioned that she did not provide this information. So in 10 days I was not able to clarify and to find out the exact EDRPOU code, whether this is Treasury of Kyiv, because typically they provide the calculations from the account of Treasury of Kyiv, but this is the sum that is just 860 hryvnias, and since this is the income brought to the family by wife, I just stated her in this declaration. Obviously, if I was a governmental worker and I understood that I could receive the obligation from NACP to correct this mistake. I believe that there is no penalty for this sort of mistake, but I could receive the request from NACP to correct this mistake. In this case, I would probably consider the option to say that a family member did not provide information. But since I filled out the declaration for the competition, I just stated my wife as the income source. That's it. Thank you.
Yes, thank you for your explanation. But I have also another question concerning declaration. As you see, we have many questions concerning fulfilling of the declaration. It's concerned the apartment, because in the declaration for 2016, you declared in joint ownership an apartment with an area of 46 square meters in Cherkasy, but did not indicate the rest of the owners of this apartment. You also declared the right of joint ownership of your wife to an apartment in Cherkasy, but also did not indicate the other co-owners. However, in accordance with subparagraph B of Part 1 of Article 46 of the law of Ukraine on prevention of corruption, if the real estate is jointly owned, the information specified in paragraph 1 of Part 1 of this article shall be indicated about all co-owners in such property. How do you interpret this rule of law, and do you admit the inaccuracies made when you fill out the declaration for 2016?
Thank you for your question. Yes, I did fill out the declaration in 2016, since in 2017, in order to participate in the competition for the position of the governmental worker, I filled it in according to the legislation that was in power as of 2017 and according to the explanation provided by NACP. Back then, if I didn't have any information, I had the right not to specify the co-owner. The apartment in question was privatized by my parents. My parents, my brother, and I are the co-owners of this apartment, and since I only had 10 days to fill out this declaration, I was not able to provide the detailed information on every co-owner. So then, for example, right now the program of filling out the declaration will not allow you to submit the declaration if you do not fill out all information on the owners. And back then it allowed me not to include the information on the co-owners, but this was the apartment that was privatized by my parents in 1996, where I have 11 square meters privatized. The same applies to the apartment that is co-owned by my wife, and the other co-owners are her sister and her mother. So this was also privatization, and she has approximately 16 square meters in that apartment. So when I was filling in this declaration in 2017, the program for filling out the declaration did allow me submit the declaration without providing the information on the co-owners. Right now, when I was filling out the declaration now, I didn't have any principal motive or any major motive to hide the fact that in 1996 we privatized the apartment 44 square meters. So this is just a technical matter, and back then the legislation allowed me to submit the declaration without the information on the co-owners. So that is my answer. Thank you.
I have no more questions.
Vladislav
Vladyslav Ivanovich, I have a question regarding unpaid fines for the administrative violation. At this stage of written communication, AG stated several times that you have an unpaid fine for the administrative violation. Namely, on February 8th, 2024, you conducted administrative violation according to Article 122 on administrative violations, and there was a resolution as well as the fine and your address and the address of the violation. So my question to you, do you admit the fact of administrative violation?
Я перевірив свої банківські карти.
I did check my bank cards, my credit cards, and I retrieved some of the archival copies. In the beginning of February, I was able to pinpoint the sum of the fine that was paid from one of my credit cards. However, why I did not provide this information initially, the reason for this was because this violation was documented automatically. Therefore, on the day when this violation happened, I, as an attorney, if I do not have enough time, if I have some overlaps in court sessions, I typically pay for taxi for my colleagues, and this is when I received this fine, so I clicked paid and I paid this fine. So, in this case, the administrative protocol was documented in my name, it was filled out automatically, and I was able to check my previous bank cards, and I did find the payment of the fine in the sum of 680 hryvnias. I mean, when you work and you receive this notification and you see the button pay, you simply click pay and you just pay the fine. And obviously, when this question reappeared 8 months later, I could not remember it, obviously. However, I was able to find the fact of paying this fine. And once again, I wanted to specify that this was not the protocol that was created by the police. This was an automatically created protocol. Thank you. Also, we have several questions regarding your work in the prosecutor's office and regarding disciplinary responsibility. Namely, when performing the responsibilities of the investigator of the prosecutor's office of Cherkasy region, you, as the investigator, received a notice. So could you please elaborate on the reason for this notice? Yes, as I have explained this previously, in the prosecutor's office of Cherkasy region, I started my employment in the year 2000. And when I started my employment there, according to the rules of working in the prosecutor's office, there is a 6-month internship period. So for me, as an intern, I was appointed to be the investigator of the case that was under investigation for 2 years. I do not want to go into details of the investigation itself. However, as a person who does not want to be held responsible for some criminal violation, obviously, I wanted to proceed with this case. So I, as an intern, was working on this investigation for just a month. In February, everyone who was related to this investigation was included in the order of the notice. And I believe that even in this order of the notice, my position is specified incorrectly. So obviously they did not make a thorough check and they just made the punishment for everyone to have.
So, for example, Yaroslav Mikhailovich, who's present here, sorry, I know that you have worked in the prosecution. How can you imagine the intern during the third month of internship getting the reprimand about the problems with the criminal proceeding? And after that, I got my report on the internship was obtained, and only after that they started paying me as an intern because they didn't pay me anything before that. It was only me working in the prosecution office for 3 months. If the management of Cherkasy region of the prosecution office had to reply to this complaint, and this was a big event for the Cherkasy region because it was signed by the head of the Verkhovna Rada of Ukraine complaint. And at that moment of time, I had no chance to contest or appeal or to defend my interests in no way because I was only an intern who has worked for 3 months. So yes, I was forced on the advice of the prosecutor of the region. I had to be silent. I didn't respond to it, kept on working. And then for being loyal, for showing loyalty despite this reprimand, I was attested and I was receiving my bonus. So as far as I understand, in order to answer reply to this complaint, there were 5 to 7 different last names in order just to satisfy the complaint. Yes, I know that this complaint took place, but I cannot say that it was me who was, the one to blame in this. Because as an intern, I was under the umbrella of the region back then, and they were the ones to get this reprimand, but not the intern. This is a nonsense, There are people in the composition of the advisory group of experts who know how the staff work is organized. It's just not possible that a lawyer of the third, an intern would get this reprimand. Okay, let's proceed to the second case. Also by the order of the Prosecutor General of Ukraine dated September the 3rd, 2004, for unscrupulous and irresponsible attitude to the performance of official duties, violation of the requirements of the laws of Ukraine on the Prosecutor's Office and on citizens' appeal sectoral orders of the Prosecutor General of Ukraine, improper organization of consideration of citizens' appeals to you as Deputy Head of the Department for the Protection of Property Rights and Other Rights and Freedoms of Citizens and the interests of the state of the prosecutor's office in Kiev region, a reprimand was announced. So could you please also explain the reasons for this reprimand? Yes, as I have explained, to have a formal explanation of applying or of getting this reprimand by the Prosecutor General of Ukraine. Pay attention to this. And in that order of the Prosecutor General of Ukraine, I think they also have 7 names at least. And I have specified that after I got this reprimand, the head of the department was dismissed. I have become the one fulfilling the duties of the head of the department, and without withdrawing this reprimand, I got my promotion and I got another good class. And it was not my time yet to have it, actually, to get it. So this reprimand was also made as a result of certain political events taking place back then. But I say that there were other circumstances which, were valid. But for me to tell you about these circumstances, I would kindly ask you to stop live broadcast, since it's the information that I want to tell you now, it doesn't only refer to me. Well, in your written explanations, you have informed. Do you have anything to add? Well, in the written explanations, so the real circumstances that became the reason of this reprimand, I didn't inform. because this information is not only about me, it doesn't only touch me. You see, the question is that in accordance with your professional experience, you always defend your rights. Yes, you always stand your ground. And the first reprimand, you were an intern. The second reprimand, you already had certain status. Why didn't you appeal it? Well, if you stop live broadcast, I will give you my explanation and you will understand why I did not appeal it. Okay, then I am asking to stop the broadcast. Vladislav Ivanovich, let's continue this topic. Why didn't you specify in your declaration these facts of being held to liability? What was your position that they were not reflected? My position was the similar, that in October 2023, according to the rules of filling out the declaration of the judge's integrity and given the statements that were part of it, it was specified that if you have committed but were not held liable to responsibility. But as of November, they have changed the rules, and now it's vice versa. If there are these facts, even if there is no more statute of limitations. But in October, when I was filling out, those rules were valid. So I was filling out in accordance with the rules that were valid at that point of time. Thank you. Dear colleagues, do we have any other questions for the candidate? Yaroslav Mikhailovich, please. Vladyslav Ivanovich. In the period as of 2005 up until 2011, you have worked in the Council of the National Security and Defense, right? And in 2011, you were dismissed because of the reduction of the staff. So based on point 1, part 1 of Article 40 of the Code of Labor of Ukraine. You disagreed with this dismissal, and you filed a lawsuit to recognize this dismissal as illegal and losing this your income. And then you also filed a lawsuit on the lost income, the average income, because you were not reinstated in your position for a long period of time. So could you please tell me on what stage of the decision being fulfilled in the National Security and Defense Council of Ukraine did you seek the fulfillment, the enforcement of that decision? Thank you for your question. The thing is, the decision about my reinstatement was made in May 2021. It had to, and it was urgent. It had to be enforced immediately. But the Security Council did not issue the order on my reinstatement. And as you can see, the territory of the staff of the National Security and Defense Council of Ukraine is closed. I cannot enter it. Vladislav Ivanovich, my question is, I'm just trying to understand. Did you fight for, or did you insist on having the reinstatement in your position in Defense Council, or are you trying to become the judge of the Constitutional Court of Ukraine? The decision of the court was enforced in May 2023. It was enforced, yes. It was enforced, and the Defense Council did not enforce the decision for 2 years, and they actually applied to the court on how to enforce the decision made by the court on my reinstatement. But after 2 years have passed, they gave me a call and offered me, because they realized that they had to enforce the court's decision. So I came to them. We had negotiations, if I can call it that way, and they proposed me the position. I accepted it. But then there was the question, will you pay me for this 2 years, the average income that I lost? And they said, no, go to the court. And then the question was, so how can I continue working in the staff of the National Security and Defense Council of Ukraine if I will again be in the court proceeding? Do we understand you correctly? You are not going in parallel paths right now. You are not insisting on your reinstatement in the National Security Council and competing at the same time for the position of the Constitutional Court judge. You understand me right. The question on my reinstatement is closed. In May 2023. It's not relevant. No, it's not relevant. Vasyl Ivanovich, I have a small question. For a long time, you have worked in Cherkasy. Then you worked in the prosecution office in Kiev region. I would like you to provide information about your place of residence when you worked in Cherkasy, and then when you worked in the prosecution in Kiev region, and who provided you the accommodation. Thank you for your question. When I worked in the city of Cherkasy, I resided with my parents in that privatized in 1996 apartment. When I transferred to the prosecution office of Kiev region, I was very young. And I thought that in accordance with the requirements of the Code of Laws of the Accommodation Code, me as a transferred prosecutor would get the dwelling, the accommodation within 2 months. I had my friend working in Kiev region, so I, for 6 months, lived in his kitchen. He rented the apartment, and I lived in his kitchen. I was waiting for being provided with accommodation. But when 6 months later, I realized that nobody was going to provide me with the accommodation, I rented a room in the hostels, in the student dormitory. And this way, I did not have my own accommodation. So I lived in the dormitory, and there was even some period of time when I had rented a place that was non-residential, a non-residential building. And up until now, I am registered in a dormitory, despite the fact that in 2023 I registered my ownership right for the apartment, where because of technical reasons I cannot register my place of stay. But up till now, I am still registered in the dormitory. Yeah, I rented the room in the dormitory. And this accommodation that you got in 2023, did you get it from the state or at your own expenses? In 2013, on program of youth loans, I got my loan, and I paid it off in 2023. So for 10 years, I had my ownership rights, and the house was formally in maintenance in 2014, but I could actually move in and start repairs in 2016 or 2017. It took me 2 years to do the repairs. And in the beginning of 2018, my wife and I, we moved into the new apartment. But I had the ownership rights, the property rights. So I have paid my loan in 2023 and submitted my documents for the ownership right. And it was registered in October 2023 because of the complaint by the Ministry of Justice, because they decided not to register it for the first time. So answering your question, if to be brief, in Cherkasy I live with my parents in the privatized 11 square meters that belong to me, right? It seems like it was my own apartment. But in Kiev, up until 2018, I was just renting rooms in the students' dormitory. So once you become the judge of the Constitutional Court of Ukraine, you are registered in the dormitory, and so you will again apply for the apartment or accommodation. No, I will not. I understand your question. I cannot do that because in my ownership I have a two-bedroom apartment, and as I already mentioned, in October 2023 I got the ownership right. So I mean, in order to claim rights for the accommodation, I have to be in line with the criteria of the person who can apply for it. But you are officially registered in the dormitory. Yes, but as for the register of the immovable property, they have the registration there. Okay, I'm satisfied with your answer. Thank you. Dear colleagues, any other questions for our candidate? If there are no more questions, Vladyslav Ivanovich, you can make a short closing statement up to 5 minutes. I would like to thank for this interview, for your work. I would like to wish you all the best in making your decisions. Thank you so much. Thank you for today. Thank you, Vladyslav Ivanovich, for your answers. And so I announce the interview completed with Vladyslav Ivanovich Ivashchenko.